assault with intent to do great bodily harm, less than murder. Count 4, assault to do great bodily harm, less than murder. Count 5, police officer assaulting, resisting, obstructing, causing serious impairment. Count 6, police officer assaulting, resisting, obstructing, causing serious impairment. Count 7, assault with intent to maim. All 3 cases are scheduled for examination.
Good afternoon, everyone.
Good afternoon, Your Honor. Daniel Hagman, on behalf of people.
Good afternoon, Your Honor. Wyatt Harris, P54891 on all 3 matters.
Good afternoon, Your Honor. Harold Collins here on behalf of our client, Mr. Michael Montgomery.
Mr. Montgomery, you may be seated. Today is date time scheduled for our preliminary examination. 1, we did have some conditions. I just want to place those on the record since we have a high presence of media today. Okay. So that being said, we have Free Press, Detroit Free Press, Detroit News, Channel 4, WDIV, Channel 7 as well. We had certain conditions that were spoke about sidebar, and I'd like for those to be put on the record at this time. Madam Assistant Prosecutor, you were the one who had some conditions you wanted adhered to. So if you can place those on the record.
Certainly.
We won't have any misunderstandings about it in case someone else just comes in who did not have the opportunity to be in the back with us, that sort of thing.
Okay. On the homicide, I'm asking that no faces be video recorded. So I don't have any objection to audio, but I would like for there to be no video of faces, so nothing from the neck upward. On the sexual assault case, I don't want you to video, an audio, but no video, and I would like you to not name the victim. And I think that's it.
All right. Any provisions for defense?
No, Your Honor.
Thank you very much. I appreciate that. The second thing I want to ask is we have 3 cases. We want to hold them all together at one time, or how are you going to organize this, Madam Assistant Prosecutor? This is probable cause hearing, so.
I quite frankly don't really have a preference how the court does it. If you want to do them separately, and once I'm finished with one, I can make the motion to bind over, or we can do them all together, and at the end I can make the motion to bind over. But my intention was to do the homicide first, and then the AWIM, and then the sexual assault.
The court has no problems with that. Any problem with
No objection.
All right, fine, thank you. Any other preliminary matters?
I would ask for a mutual sequestration order with an exception for my officers in charge.
All right, any objections to the exceptions?
No objection.
Thank you, very good. So we do have a sequestration order. If you are a witness in this matter presently or in the future, kindly remove yourselves from the courtroom. If you all can take a look, I'd appreciate that so we can have the room cleared out if that's the case. Ma'am, in the second row, you have a hat on your head. Would you take all dressings off your head? Yes. That would be good. Thank you, ma'am, very much. Any other preliminary matters? Motion. Thank you, Madam.
Your Honor, at sidebar, we talked about the matter of me getting discovery about 2 hours ago. And I asked the court for a specific motion based on the fact that I have not had an opportunity to review that discovery, that specific discovery. And it is quite different than what was discussed with regards to the information that I did receive in the discovery, earlier discovery.
Okay. If you want to say, ma'am.
That's true. I received the final DNA analysis as it relates to the 4 rape kits. The information that we had in the past was that these 4 rape kits hit to each other in CODIS. As the court is aware, CODIS is the combined DNA index, and it had hit to each other with an unknown suspect. Through police investigation, they got a tip, or some information was developed, that the defendant, Mr. Montgomery, was that unknown suspect that would match to those 4 people. They had gotten a buffalo swab from the defendant in a previous case and had that sent to the Michigan State Police Crime Lab to compare to the 4 unknown hits that were hitting to each other within CODIS. That final DNA analysis with the defendant's buffalo swab that was taken at the time that he was arrested on this matter, these matters, is now, they're now able to say that the defendant defendant's DNA matches all of those rape kits. So the CODIS hit, it's just a reiteration of the CODIS hit saying that the defendant is the one that matches on those 4. So go out and get a new fresh buccal swab just for the confirmation purposes, and that has been done. It's the people's position that the information is in those reports is nothing earth-shattering. It's what we've known since before he was arrested on these cases.
And you wanted to respond?
Yes, Your Honor. First off, Mr. Montgomery is entitled to effective assistance of counsel. And giving me this information 2 hours before an exam renders me truly ineffective. I would obviously want to have an expert look at this. We would have had to, had we had this information, and I would indicate to you, Your Honor, I did get a chance to look at one of the exhibits, the latest email that I would receive, and it's dated November the 5th. Now, the prosecutors indicated to me that they go through that the police go through some processes to make a determination as to whether they should release it or not. But if this information was completed November the 5th, I should have gotten it some time ago. And I believe that the discovery that I did receive
For all of you,
probably
if you have any
somewhere
questions,
around
yes, please.
the latter part of October, the first part of November. So the people and the police have had this information for some time, and in order for me to be prepared, I would need time to prepare for this exam. I don't know what I'm going to have to deal with regards to the 4 or 5 witnesses that we're dealing with, and challenging this particular DNA information that came to us in the email this morning. So Mr. Montgomery is entitled to effective assistance of counsel. I'm rendered ineffective today.
All right. Okay, then. As to the sidebar, you did mention that the information was available earlier.
I did.
I thought, or I don't remember that. I thought I heard that Madam Prosecutor just received the information Friday, the day after Thanksgiving, and she sent it to you as soon as she could. So.
I would indicate to this court that when we came out here to review the documents that the prosecutor is looking to have me stipulate to, when I looked at this latest report, I looked at the date complete, and it says November the 5th. I didn't know that when I was in sidebar.
Okay. All right, then. Okay, so that being said, that's something to consider. Anybody else want to speak to that?
Yes, Judge, I would indicate for the record that I received the one that defense counsel is indicating, which would be the final DNA analysis as it relates to Ms. White, Daytona White. It indicates that it was completed on November 5th, 2015. I received that today at 9:55 a.m. And the other 3, as it relates to Emma Mark, I received them on Friday, but since I wasn't here, I didn't get them until this morning, but they technically landed into my inbox, let's see, at around 11:31 or so on Friday. So I sent them, as soon as I got them, I sent them to him. Now, the reality is that I wasn't going to go forward, even put these in today, because the CODIS hits, I believe, satisfy probable cause. So if the court wants to go forward, I'll just use the CODIS hits, which are reports that say that these different hits are associated with the defendant. I think that is probable cause. That's how we get the search warrants, to be able to confirm that it's the defendant. So if that's the issue, then we can just go forward with the CODIS hit report that says these rape kits are being associated with the defendant. I personally don't see the difference between the final DNA report saying that it's him and the CODIS hit saying that it's him. I also would note for the record that pursuant to statute, defense counsel doesn't even get to cross-examine those witnesses because they come in under the new statute, and I believe it's 766.11b, I think. Before I misspeak, let me actually get the site. 766.11b, which indicates for the record that reports that are kept in the regular course of business, except for a police report, investigator's report, or report prepared by a law enforcement officer or other public agency, are permitted. They include but are not limited to a report of the findings of a technician of the Division of the Department of State Police concerned with forensic science, a laboratory report, a medical report, a report of an arson investigator, and an autopsy report. So for today's proceedings, my intent was to put on responding officer and a woman who says she saw certain things around the time of the homicide, and then admit the medical examiner's report and all the DNA reports, and then make the motion for bind over. So the fact that we didn't just receive these today, I provided them as soon as I had them, but was planning on being able to go forward without even having the final analysis. But since we have them and they confirmed what we've known all along, that it is the defendant's DNA, I still don't see the issue.
The issue, quite frankly, Your Honor, is the wording in the reports that were delivered today and the wording in CODIS would cause you to have to think about whether there is probable cause. Absolutely.
Well, if they just proceed with CODIS, though, that's what they present to the court. The court will have to make a determination on that. So you arguing against the DNA results, the final results, but if she just moves forward, the prosecution just moves forward with CODIS, the court has to make a determination whether or not that's probable cause.
That's true.
Even though the prosecutor's indicated to her, she feels it is. The court will make that determination.
So you're going to have to make a determination what association means. That's exactly what you're going to have to make a determination on.
Well, if there's probable cause, that's what we hear about.
And I would indicate to this court that we may, given these reports and given a review of our experts, we may have taken a different position with regards to whether we even want to hold these.
Okay. So noted. And the court was considering starting the exam and allowing you to put your experts, if that's what you're going to do, look them over. You have a more thorough look over as well.
Right.
But given what the argument that we have today, I think we have enough to proceed on the preliminary examination. The people present what they present, and the court just has to make a determination. So that's what we have at this particular time. We will move forward now, today, with how many witnesses, maybe?
I think it's going to be at least 4, but for all 4 or all 3 cases.
Okay.
But
We'll see.
we'll see.
Okay, and that being said, are we ready to proceed at this time?
Yeah, because of the way that the court has now ruled, I need just a minute to pull that last report out.
Sure.
And get it mixed in with take the other report out and put the new report in.
Sure, and while you're doing that, the court will do a little housekeeping, because we had someone come in with a camera. We're off the record now. Your name, sir?
David Coates from the Detroit News.
Hi, Mr. Coates from Detroit News. You have a card with you?
I have a, yes ma'am.
Please pass it up. And did you get the conditions that were placed on media at this time?
Yes, ma'am.
Just want to be clear.
Yes ma'am.
Are you finished setting up?
Yes ma'am.
Thank you, sir. This is ID. This is ID.
Yeah, I don't have a business card.
Rescue. 2 brothers save a bald eagle.
Nobody's asked, even you guys who took you in the back. This is Judge Hennett Johnson, say that correct? She's a new judge and she's sitting in. She's sitting in, seeing how things go. So that's weird to me how nobody asked. Nobody said that. They might have said something that didn't tell us, but I'm surprised the media didn't ask. They're like, whatever, we just want
Must need 2 judges.
or something to that effect. I expected the media to ask. Nobody. Why is there? Get the name right. Hennett-Johnson.
You have 1 through 4 there, is that right?
2, 3, 4, yes. Yep. Thank you, ma'am.
I'll make So you can move stuff around as you see. So all right, we're back on the record then. Let's proceed.
Thank you, Judge. I move for the admission of People's Exhibit Number 1. It is the post-mortem report on ME case number 06-00023. It was completed on the body of Antona White, January 2nd, 2006. It was completed by Dr. Melissa Pasquale Stiles. It's PASQUALE-STYLES. Her report indicates that the cause of death is multiple stab wounds, and she indicates in summary and opinion that Antona White, a 16-year-old black female, died of multiple 4 stab wounds of the neck. As reported, her body was found in an alley, nude from the waist down, with her legs spread apart. At autopsy, she had a stab wound on the anterior neck under the chin, stab wound number 1. The track passed through the muscles of the right neck, right internal jugular vein, without injuring the right common carotid artery, for a total wound track length of approximately 3 inches. Hemorrhage and tissue destruction were along the wound track. The track was from front to back, downward and toward the right, and viewed in the anatomic position. A stab wound was on the left upper neck at the inferior edge of the mandible, stab wound number 2. The wound track passed through the edge of the left sternocleidomastoid muscle, left submandibular gland, left internal jugular vein, left common carotid artery, left thyroid cartilage, and left arterioepiglotic folds for an approximate wound track length of 3.5 inches. The track was from left to right, downward, and toward the front when the body is viewed in the anatomical